Hunter, I'm going to break my argument down into four parts for the court, but before I do, I must say what part of this case is not in dispute. And that is that Ms. Holly Bobo and her parents and friends and family are the people who make West Tennessee a special place. The horror of April 13th, 2011 remains an unmitigated tragedy, and nothing I say diminishes that. An outrage that this crime took place is not relevant in these proceedings. The four parts to my argument are the story of this case. I'm going to address constitutional violations. I'm going to address the proceedings themselves, these post-conviction proceedings themselves, and end discussing the obligation that the court has. Before I get too technical in the legal arguments, I'd like to just summarize this case. April 13th, 2011, a beautiful young nursing student was taken from her home, traveled in a clockwise manner until her cell phone stopped traveling for 30 minutes. This is where U.S. Marshal tracking expert suggests she was killed. No evidence before that was found along a route. A bullet consistent with a defect in her skull was found next to her remains. Evidence was thrown out for personal belongings from that location along the route that ended at Gooch Road. Most of her personal belongings were found next to her remains. I will not belabor the evidence that made law enforcement and General McAdams submit there was probable cause that Terry Britt committed this crime. Britt had a search warrant served on him and installed, while he was briefly incarcerated, various wiretapping and bugging devices. Soon after he returned, he was told they probably are bugging you. Nothing happened. 2011 turned into 2012, turned into 2013. This case was becoming a cold case. Terry Britt told Marshal Walker to get an agreement giving him certain prison time. He just wanted his wife Janet kept out of it. He was not Mirandized. He took 15 years on old charges that Janet Britt was let out. By the way, if he had been serving for that crime that happened in Madison County, he would have been incarcerated on April 13th, 2011. In the words of Brent Booth, this case is haunting. As time developed, TBI blamed the Bobo family. The Bobo family blamed TBI. Nobody could blame them. What follows that began in late 2013 can only be explained by understanding the juxtaposition of impenetrable truth that scientific data provides and the manipulative propensity of what people say. And these people who are either scared, want reward money, or have their memory replaced with inferences and impressions to regurgitate or, quote, nail down. Enter Dennis Benjamin. He begins working with TBI head agent Jack Van Hoosier, retired cop, becomes the go-between between the Bobo family and TBI. His job was to get some arrest. Enter Sheila Kilzer. Her son was arrested with Jason Kilzer. Put aside that both Sheila and Jason had already denied knowledge or involvement. Sheila and Jason get law enforcement to believe Dylan knows more. TBI pounces. Even though what Sheila heard was false, TBI begins the belief that continues throughout that they have the omnipotent superpower to know what the truth is. and thus anything that points to arrest is true enough to further their aim. This is a central theme of everything you've heard. Dylan is pressured from jail. He gets a sweetheart deal, the contents of which are under seal. I will not discuss that. I would just ask the court to read it. A word about Dennis Benjamin. He had been told in February of 2014 by Victor Densmore that Dylan was the weak link. In March of 2014, Benjamin is back in Indiana telling Densmore that he's going to get the death penalty if he doesn't tell him where the body is. In dismissing Benjamin, Densmore says, "I'm not even interested in the reward money." We are to believe that a drug addict's statement to his girlfriends, his drug buddies, and other jail inmates are gospel. All are statements that were provided or not provided or misconstrued to the most vulnerable of our citizens. They were worried about arrest, losing custody, reward money, and thus everything the state has mustered in an ambush of these people, or to put it into their words, run to the ground. Persist until they say enough to implicate these four, even if it's inconsistent, even if it's demonstrably false. It doesn't matter. I could not summarize this part of the case better than Agent Joe Walker did on page 483. There were a lot of statements that ended up not being true. Now it's time to find the credible points of data that corroborate this scientific data that cannot be manipulated. None exist. Every single part of their life was searched for DNA evidence. None. Fingerprints. None. A gun that could have been used in the crime. None. Nothing. Not the palm print at the Bobo house. Not the crop print. Not a single thing. They have that a meth addict scratched his arm. Dylan's statement is thoroughly rebutted by the cell phone records. It's no wonder why within weeks of Jason Autry's story being released, his attorney wanted the cell records just one more time. Instead of saying Dylan's story was not true, the state has tried more creative avenues by saying it was too self-serving. After he made the statement, he was politely escorted to jail where he has been ever since. Fugitive tracking experts placed the location of death where the remains were found. He was needed to be an expert when the state was trying to solve this crime. You heard from Agent Frizzell today. When his opinion did not fit within the strictures of the manipulated testimony, he was discredited. Could not show it any better today. Agent Frizzell and I recreated Marshall Walker's map. The foundation of my entire trial has been trying to explain April 13th, 2011, and when I finally had Agent Frizzell under cross-examination, he showed the same thing. Bank records were pulled of Shane Austin to call his bluff to see where he was. They confirmed where he was. He said he had a satellite guy coming. That too was corroborated. Cell records put these four throughout Decatur County and Benton County, and it never put them in Swan Johnson Road's location. Zach Adams' phone, that apparently was with him all the time. 8:19, he's receiving incoming text. 8:17 and 8:26, Miss Holly Bobo's cell phone is on a completely different tower. Facebook showed Zach online that morning. Nothing made sense, and yet these men were on trial for their life. Zach Adams' defense attorneys were told, get the ATM video by Dr. Norton. The bank said no such software existed. The TBI agent said the ATM transaction was not covered by their videos. Someone had mislabeled them to be a BP video. Thompson couldn't even open whatever it was labeled BP. And a word on an alibi. We heard delicious. They said that this ATM was baking an alibi. Well, one thing about baking an alibi, you tell law enforcement. Why didn't they tell law enforcement about the ATM? You heard Walker and Booth say, I don't remember the last time I went to an ATM. I doubt anybody in this courtroom remembers the last time they went to an ATM. They say that every time they gave law enforcement, they lied. They're on drugs. They're saying what the things they remembered of that day. The state says all of the things Zach Adams said, all of it under the influence of drugs, it was gospel. Terry Britt talking to an agent in jail was sarcasm. In the face of this, Jason Autry chooses a better option. Recreate his day with cell phone locates. He says he remembers 6 years earlier, while under the influence, somebody mowed his yard, somebody mowing their yard. Interesting that Brent Booth said, remember Autry said he remembers the guy mowing the yard. The state never once yielded any misbelief about the totality of his testimony. They told the court Autry told the world that day. You can read Jennifer Nichols' closing argument about Autry. And she says specifically, Jason sort of covers the whole morning, page 2,727 of the transcript. Sure, they got the gun wrong. Sure, Autry got the gun wrong. That could be fixed. The .357 became the .38 revolver with a .357 barrel became the murder weapon. Disregard Dinsmore vouching 6 days prior that it was a .38 revolver with a .357 interchangeable barrel, and he knows his guns. Disregard that he says, now my wife also threw out a .32 revolver. Disregard that. There has to be right objective data that the state needed. The defect was .36. The bullet casing next to it was a .380. It's excluded. Nobody pull your phone out to just see for yourself. They say, oh, Bradley Strawn sold it to Shane Austin. Disregard Bradley Strawn's testimony. That never happened. Problems again with Jason Autry. Okay, the white truck was never in the picture. That was the murder getaway vehicle. Dinsmore must have just forgotten that, quote. Let's send Booth up there to, quote, nail it down. One wonders how much testimony in this case was nailed down between Dennis Benjamin, Brent Booth, Victor Dinsmore, and the rest of the agents and witnesses. And halfway through this witness's testimony, the last witness, Mitchell Hayes, I wrote down my first question. I wonder if he knew Brent Booth. 5 minutes later, we learned they had friends and have each other's cell phone. The case went to the jury. Autry does his job. He saved his life. He gave the state what they asked for. The trial judge said it was the most persuasive and credible testimony he'd ever received. Put aside what we've heard in 2025 from General Wyrick's questions, which is all of us are presumed to think co-defendants, participants, immunity agreement witnesses, they provide self-serving and incomplete truth. That's surely not what the jury heard. Put aside Brent Booth had substantial questions about the truthfulness. Put aside Kathy Ferguson flat out thinks he raped her. Put aside all that. The conviction withstood the appellate scrutiny. But then one canary in the coal mine had not been forgotten about. Buried underneath 4 terabytes of discovery, everyone seemed to have forgotten it existed. And I am discussing the video of these gentlemen at the ATM. The backstory we know is Terry Dicus and Ricky Inman were going through trying to find between 8 in the morning or 7:30 in the morning and 9:40 in the morning, trying to find locations of Holly Bobo or somebody who might be driving. The records show exhibits where they were labeling, but stopping at 9:40. They had a treasure trove of this surveillance video that they dutifully labeled and then just stopped. And here's the interesting thing. So Zach Adams fills his pro se petition, and he didn't forget what he had been told. We were at the ATM. From Dr. Norton to his attorneys, the bank records show we know you're at the ATM, we just got to find it. So it's part of the post-conviction proceedings. And this is where it's interesting. Adams is talking to somebody he would not be here without, Dr. Katie Spirko. Adams, and this is recorded and listened to by Kathy Ferguson. Kathy Ferguson testified, we heard them talking about this video, the potential of it. We heard Zach say, I remember going into the ATM backwards. When I issued a subpoena to get this, the state was advised of the subpoena, they issued it too. It was limited in time, what Ms. Ferguson says, Agent Ferguson. The state was dangled the original software, and they went and got it. We'll come back to that. Months ensue. I finally filed a motion because in the January hearing on the amended complaint about this, General Boyano brings the laptop that has the still shot of the truck going backwards. The same still shot, the state also argues, shows nothing. It showed something for them to have it on their screenshot when they argued in front of you. And at that time, Zach Adams says, that's me. No one knew about it until these pleadings. No one. Agent Booth, then General Nichols lied to you about it. They said, we remember seeing it before the trial. Cannot tell you how much I appreciate Kathy Ferguson for honoring her oath and saying Booth's mistaken, because it's not true. It makes perfect sense nobody saw it. General Hagerman says he was the expert of the 4G terabyte hard drive. The 4 terabyte drive, he was the expert. He never remembers seeing it. Terry Dicus stopped surveilling at 9:40. Agent Ferguson was the lead administrative agent. She never saw it. It was only relevant in these proceedings. Walker, who was in charge of going from the bank records to seeing if they were covered by the videos, he said, I didn't see it because I didn't look. It was mislabeled by an intern. Again, Zach's lawyers couldn't open it. What does it do? And I have belabored this. All of Frizzell's cross-examination is now consistent with Walker and Reeves. There is virtually no space between them. It shows at 10:32 when Zach is on tower 39077, and then at 10:35, 39079, he's traveling on the interstate to get to their home, to pick up the rest of his drug buddies, to get down to Parsons, and that's their day. You cannot go from where Autry says they were along this route and make it to the ATM by 11:12 a.m. We've proven that. Nothing the state can ever show rebuts what the objective science reveals. All the statements in the universe, including the guy fishing whose wife was a Facebook friend and he's buddies with Brent Booth, does not rebut what the cell records, the bank records, and the ATM video show. That's why I've spent all of my time on this dry erase board. When you understand April 13th, you understand everything. I asked Agent Booth, as an investigator, is your job to tie up independently corroborating bits of data like bank transactions and cell records to say where somebody was? Answer, I didn't do that. I don't remember that. So the court must ask itself now, how can this be? And I submit it is only for the constitutional violations that took place. Your Honor, I submit first under Dellinger, I have proven that the ATM is new. It exists the same way all other new evidence exists. It was out there in the rules of quantum physics that existed. Nobody knew it. Nobody. And the fact that Agent Booth and General Nichols were not credible validates it, because Agent Ferguson and General Hagerman, you can test their credibility, validates it's new. It proves actual innocence. If I have argued actual innocence throughout this. If the court does not find by clear and convincing evidence of actual innocence, then the court's analysis falls to whether first, standalone constitutional violations warrant a new trial, and if not standalone, ineffective assistance to counsel. This evidence is largely interwoven with each other. I suggested in opening, I'll suggest again, find your facts, and then you'll understand when you apply the law how to apply a defense to the standalone grounds is whether it's been waived or whether it's been previously determined, such as if you have a suppression hearing, you can't argue in a PCR. The standalone, the Brady violation of Jason Autry's sentence was not revealed to the jury. The state had decided, General Hagerman, the state had decided they had virtually no case. They never communicated that to the defense. Autry, as a state agent, he was provided an immunity agreement, and he came to the court and he lied. I'll talk more about it briefly. Prosecutorial misconduct and or Brady violations. I'm just going to briefly touch on them. I'll get to them in a second. Jennifer Nichols telling the jury the 380 was excluded. No, it wasn't. That the truck had been put in the Dinsmore's garage. No, it wasn't. That the ATM video was buried in discovery that nobody knew and then mislabeled. And at this point, I think the court can see, when I asked Agent Frizzell, did anybody try to go back and look at this surveillance data? I mean, just think for a minute, the millions of dollars, it's in the transcript, the millions of dollars the state had for this. But they act like it's an inmate and an appointed attorney's job to find a better, more clear version of ATM surveillance data. I think I've covered sufficiently how the ATM came to be. I want to go over some of the things the state has said in regards to it. They argue both it's nothing new, we knew they were in Parsons, who cares? And also argue perhaps a canine was driving it. They argue you can't tell if it's them. You can't tell if it's their same vehicle, although to his credit, General Hagerman says, yeah, the same hubcaps, it looks very similar or similar. It's the exact vehicle they had impounded. And what nobody in the state has said is, if that's not them, what vehicle was Shane Austin in? Because the transcript shows they knew his vehicle was inoperable. And they knew that bank transaction took place. Dylan Adams said, that's me, the BP, standing there. Dylan Adams said, that's me in the car. Zach Adams said, that's me in the car. Jim Simmons testified, so far as we knew, there was no video. He's the one that subpoenaed the bank for the video. They both said they never saw it, and they said how important it was. Gonzalez remembers no conversation about the ATM video. Its importance was understood at trial. That this route that I have discussed about Autry's lie, if you read the trial transcript, and General Nichols, she knew when to object. Page 1,313. And remember, the testimony is that TBI agents, they ran the route themselves. They knew the route that Autry was going to testify about. The question discussing the way back. Question on line 10. So then where would you have gone after that? Answer, at some point in there, it was determined they were where they was, and I proceeded to make my way to 30 Yellow Springs Road. How did you make your way over there? Answer, maybe through Coxburg West, comes through at Eagle Creek. General Nichols. Your Honor, at this point, I'm going to object to when the witness says probably. If he doesn't know, I'm going to object to him just guessing and speculating about which way he went. She knew exactly what she was doing. As if she knew the route was impossible, because she's the one that says today or in November, we knew they were in Parsons, big deal. We'll come back to that when we discuss sanctions. The gun. It's not merely what gun was used. The gun, the .380 round next to the remains, is important because it is another bit of data that validates John Walker's map. I was more worried about this because I prepared this before Agent Frizzell testified. We are now in unison with that fourth ping added to Miss Bobo's phone. But the gun, the .380, shows the 30 minutes from Shiloh Road to Truck Tower Road is where Miss Holly Bobo was killed. Everything makes sense. There's no evidence thrown out before. The evidence is thrown out after, except most of the physical remains of Miss Bobo are by her remains. Six days before the .32 revolver was pulled out, Victor Dinsmore says, I'm 100%, I know my guns. It's a .38 revolver with a .357 interchangeable barrel. Jason Autry initially said it was a .357. Why did he say it was a .357? Well, Maybe he knew the Austins had a 357. Maybe it's based on discovery that a 357 had been pulled out. But when the state pulls out the .32 revolver, they don't say, maybe we're being lied to. You know what we haven't found in the 2 years of this post-conviction proceeding? The .32 revolver that Victor Dinsmore says they threw in a pond. That May 2017 recording not only revealed the gun issue, if that's not suborning perjury, I don't know what is. It's rare you see the sausage being made in an investigation where 6 years after, Brent Booth is asking Victor and Sandy Dinsmore, could it have happened? No, not happening. Brent Booth, I'm trying to get all these details nailed down so I can settle this damn case. His words. Victor says, there's no way that's happening. You never know what a jury will do. Booth says something interesting then. He says at the time they were hiding the garage, they were cleaning the truck out to hide it. There is no scenario where that's possible on April 13th, 2011. None. Victor says, let's go with it. Let's put the truck in the garage. In the state, the prosecutors don't say, well, I'm cleaning my hands of Victor Dinsmore. I'm cleaning my hands of Agent Booth. The words were, they were unimpressed and he was leading. Jennifer Thompson knew enough to have it transcribed, but she didn't understand Rule 803.26. She didn't understand none of it's offered for the truth of the matter. She should have cross-examined them. She should have talked in opening statements. But when she tried to bring it up, shrewd as always, General Nichols objected. Can't talk about that. When we started these proceedings, Your Honor, I did not, one thing I forgot. It's interesting, there are moments where you see how Autry recreated his story. The truck in the garage is one of them. Valerie Trout's IR discussed that the Dinsmores remember a truck being hidden there. But Trout said, no, it wasn't the day of. She came here and testified. It wasn't the day of. If it was the day of, I would have put it in my report. But Autry gleaned from that, I need to put the truck hidden in the garage. When the case started, the first day I lost the motion in limine on Autry's testimony, I did not think I could prove to the court Autry lied. I didn't have his recanting. And it's interesting, the state said it's not credible because Autry was under the influence of drugs when he's talking to my agent at the Memphis jail. But now when this drug addict's talking to other drug addicts, trying to intimidate them, it's gospel. When we started the case, I don't think the state had the understanding of Dylan. Because all you have to do with Dylan, and I know the court said it's going to watch the tape, you have a transcript, I can't request enough. Absorb it. Dylan says whatever they wanted him to say. And so initially, during these proceedings, I was asking, they started off with Mark Lewis. And we get into this, what I'll refer my words as hedging. Again, to the jury in 2017 is totality. Autry's plea, Autry tells the world, Judge McGinley, most persuasive, credible testimony I've ever seen. Watch what happens in 7 months. General Wyrick is asking the first TBI agent to testify, Mark Lewis. Question, this is page 238. Is it fair to say that Jason Autry's statement that he's given to law enforcement over the years, as well as Dylan Adams' statement that he's given to law enforcement over the years, are not mirror images of one another? They're not mirror images. How many homicide statements have you participated in your career as a TBI agent? I don't know what the number is, but it would be a lot. Okay. How many of those have involved a co-defendant? A fair amount. Is it typical with co-defendants pointing the finger at one another? That's not uncommon. It's typical. Sometimes they do, sometimes they don't. Sometimes they give you a little bit, try to mitigate their own involvement. That has happened, yes. Give you just enough to let you do your work without completely, and I object. I said, Your Honor, is the state acknowledging Jason Autry's statement and testimony was false? Because that will save us a tremendous amount of effort with this line of questioning if the state is acknowledging that Jason Autry's statement was false. General Wyrick, I'm nowhere close to that, Your Honor. No, sir. Now, fast forward to Kathy Ferguson. May, August. General Wyrick asked Kathy Ferguson, of the 4, who do you think raped Holly Bobo? She said Zach Adams, Shane Austin, Dylan Adams, and Jason Autry. Oh, so you think Jason Autry raped him? Yes. All because you just listened to Dylan Adams' statement. And you realize it's a lie. Now, General Nichols says 2 things on her testimony. She said, initially, I knew it was false when I watched it. She and I agree on that totally. It's interesting, though, he got incarcerated immediately after making it. I know of no other crime where you say a lie about your involvement in a crime and you're not arrested. The problem is when Jackson and Booth are good cop, bad copying him and saying all this, nobody had the cell phone data. To say that this is not a mirror image of Jason Autry is an offense to the mirror. Dylan has this concoction coming up over the entire night and has Autry the ringleader, has Autry throughout the day raping her, has Dylan raping her, has Zach raping her. Then when you watch it in full, you'll get to the point when they say, and they were hiding her in a basement. It's like, whoops, they're talking about a trailer. So it starts all over. And you go back to the sealed transcript of the plea deal. And you think about Dennis Benjamin and what we heard from him. February, meeting Densmore is a God thing. He's got a friend in Indiana. March, he's lying to him, saying you're going to get the death penalty. And that's who the vulnerable one lived with. I want to say this about Autry's lie. Credibility matters. I got the pattern instructions. Pattern instruction 42.04. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. By the way, the dedication to this year's pattern instruction was to Judge German. Judge Riley wrote, Dickey abhorred anything he considered to be an injustice. But the state says, okay, in 2017, we said Jason Autry, total mourning, total testimony, total truth. Now they say, oh, you silly jury, you should have known better. You should have known that co-defendants do this. You should have known that it was a self-serving statement. You silly jury. I have custody cases all the time where you lose custody of your child if you lie. I don't say to the judge, I mean, listen, dads lie, moms lie. You know, it happens. Don't follow the law. The fact that their lead agent says Jason Autry was not truthful, but they find a friend of Brent Booth to come here and say, on a random day crappie fishing, he remembers a gunshot going off, and he remembers it echoing, and the court will listen to the exhibit. You listen to them. They're labeled how far apart they are. You listen if you hear any echoing. When he got up about halfway through, I wrote to write this question before he said anything. I wonder if he's friends with Brent Booth. Called it. We did not know, the record did not know that Dylan, this all started with Sheila Kilzer. Kudos to Mark Lewis. He testified Sheila Kilzer wanted her son to get a deal. Kudos to Mark Lewis for explaining that. Your Honor, I think this record has been aided by what Dennis Benjamin brought to the court. The court's heard several issues regarding Sheila Kilzer, Rebecca Earp, who said the truth when she was interviewed by Valerie Trout. Again, the cell phone records have Zach and her arguing throughout late at night. And she's asked, did y'all spend the night together? And she said, I honestly don't remember. But that wasn't good enough for the state. They had to nail that detail down differently than her memory. Dinsmore, and this was something that Jennifer Thompson did not bring out. There's moments when there's these witnesses lining up, and then there's these moments when they don't know the latest thing to line up with. And so Dinsmore is saying that while these guys were there buying drugs on the afternoon of April 13th, they're talking about who's going to hit it first. And there was a while where the state believed that to be true. And then the cell records come in and like, whoops, that's not true. And Autry's painted a story with cell records. The victim's already dead. And you hear Dinsmore says, oh, like, whoops, somebody forgot to tell him. But he still said it, and it made no sense. And Ms. Thompson did not isolate on this. John Walker, I appreciate Agent Frizzell. You know, if the record reflected at trial, the only thing he was wrong about was a road here and there, that would have been pretty different. I've thought about this. What's more accurate? The map John Walker prepared that the court did not allow in 2017, or the exhibit that Agent Frizzell prepared with consultation with the state that had the fourth ping missing that showed the direction of travel of the cell phone of Holly Bobo that morning. When Agent Walker was preparing Ms. Thompson, his testimony was it was for an hour, she did not pay attention, and she was drinking wine. the credibility of Jennifer Nichols and Brent Booth. They're the only two who said, I saw the video beforehand. Your Honor, I submit there's credible evidence that the court received then General Nichols, who testified in November, was the least credible witness this court will ever see. She objected to some of my questions from her chair, ridiculed, deflected. It was beneath the position she has held. At times when she couldn't find the right answer, she attempted to gain sympathy from the court. Interesting, she said something I'd heard from Jason Autry that said, if your records reflect that, I don't dispute that. Interesting. I wonder how that came to be. At one point, not wanting to answer the question, she said, when are we going to talk about Jennifer Thompson? I thought that's why we were here. Listen to her at the trial. Jennifer Thompson, all she had a guy who measured the .380 round in the casing. And she told the jury, he didn't know to take the bullet out of the casing. Bless his heart. As if somehow the bullet's going to get bigger than .355 when it's removed from the casing. As if the sock is bigger than the shoe. And then when you ask these people simple questions, just think about this. Simple questions. Do you know the diameter? Be honest, people. Agent Ferguson said, I didn't, but I've learned it. Jennifer Nichols, no. Have you Googled it? No. Brent Booth, have you looked it up? No. Just admit we were wrong. The sanctions that the court has taken under advisement. The state is asking for the court to see that somehow that video that is in discovery either shows nothing, or if it does show something, it shows nothing new because everybody knew we were in Parsons. They said, but Katie Spirko can't go get it because it's evidence. Which is odd. From 2011 to 2024, the state did nothing to go and get the actual recorded software. Only when Katie Spirko tries to get it through a subpoena that only I have the power to get, then all of a sudden we got a problem. And you can look through the record of this transcript to see their only defense to the ATM video is it's not clear enough of a picture to see who's in it. It's almost as if the real reason they went and got what's exculpatory evidence was to make sure if there's a clear video of it, the defense didn't have it first. And when I asked her whether it was important, whether she communicated to me first, that they went and got it, and they told the person who gets it, don't tell anybody, Jennifer Nichols says, who cares? It's an obligation under the rules of professional conduct when a prosecutor knows of exculpatory evidence. And you saw Jennifer Nichols' attitude. All of these things, Your Honor, combine for these standalone issues I've addressed in my pleadings. I'm now going to address ineffective assistance of counsel, and I have 12. I'll not belabor the point. Again, if I have not proven these are worthy enough on its face to survive the Rule 28, Section 5 defenses, these fall to ineffective assistance. Number one, Dylan's video. And it was odd to even watch in real time. The question was, how do you authenticate the video of Dylan's September 2014 hearing? Jennifer Thompson says, I don't know. It's pretty easy. You call one of the 3 TBI officers who were there. And it's not a confrontation issue because, first of all, it's not being asserted for the truth of the matter. And second, the defendant calls it. And look how the state, they couldn't wiggle out of it. 2, she never recreated the day of April 13th to make it sense with the objective data. 3, the gun, her question to Dinsmore was, yeah, but didn't you say it was a 38 or a 357? That's fundamentally different than you said it's a 38 revolver with a 357 interchangeable barrel. Number 4, the truck in the garage, she had the transcript. Play it at opening. Say, ladies and gentlemen, this is how the evidence has been created in this case. All of these witnesses said different things until the state said, that's enough, stop. The detail is nailed down. Jerry Gonzalez says she wasn't listening because she was constantly trying to get boxes because the state wouldn't tell them who their witnesses were. And the state during these proceedings said, no, that wasn't done. General Hageman tried his best. When we asked a couple of weeks ago to the state, who are your 6 witnesses? Their response to the court seen it was, are we required to do this? Britt, technical difficulties regarding the wiretap. Britt admits there's listening that you're told they probably wiretapped your home. This idea that there was not probable cause differences, Your Honor, I've gone through this. It's not the case. There's a probable cause for an administrative subpoena, investigative subpoena, that's different by statute. Everything else, the definition of probable cause is you believe somebody did it. That's it. Think how I went through point by point by point of Brent Booth, who initially said, I never said there was probable cause. And then I get the record out. And he's like, whoa. And we went through point by point. Terry Britt lied about his alibi. Terry Britt lied about his cell phone. Terry Britt's prior knowledge of Holly Bobo. Past behaviors. Thompson could not open a video. She should have gotten IT help to open it. In fairness, she did repeatedly bring up issues to the court. The transcript of the motion hearing speaks for itself. She failed to isolate the Dinsmore when Dinsmore said, yeah, those guys were talking about who's going to hit it first. And then I didn't know what they were talking about. Now I do. I feel terrible. So she said, wait a minute. The crime's already taken place and she's dead by this time. She didn't isolate how all of these witnesses, just because they say some things that sound similar to other things, it doesn't make it true when you have people who are facilitating these witnesses back and forth. She should have played the ERT video. Honestly, I don't remember. She didn't force this fundamental question of the day, which is, they just pulled off the crime of the century. They just get back to Austin's house. The records show their call was at 8:50. They now have no idea what to do with the body. So they call Jason Autry, who comes in where they drive to the river to dispose of it. They then don't dispose of it, and they drive all the way back. Put aside they drove, and you'll watch the video of Paul Dillon's route. It's nothing but woods. But they're still driving. And then at this point, even though you cannot get to this route, Thompson does not say, does it make sense now that they say, all right, we know a satellite guy's coming at Shane's house. Let's just leave everything here and make our way to Sonic, that's what the proof that Autry bound them to. Put aside this issue. The remains were found with personal property. How'd the personal property get there? If they were throwing all the evidence out, wouldn't they have thrown all the evidence out? Instead, they made sure to keep some belongings together, and there's no explanation for how that could be. Because they say the truck was hidden in Dinsmore's before all of this. It's impossible. And Thompson never drove that point home. She should have told, number 11, she should have told Zach Adams, Zach, you're on trial for the death penalty. I need to let you know I have antidepressant medicine that's being upped up because of how I'm being treated in this case. You say, well, that's true, but somebody was being mean to her. Is the attorney's job to not at least tell the client, you need to know my mental health is deteriorating, which is the 12th point she should have withdrawn. I could not say it better than Forrest Richardson. He analyzed quantity, not quality. Jennifer Thompson's problem is not that she didn't know the case. She couldn't tell the jury about it because by September 2017, she'd been ridiculed. Her own co-counsel filed a motion to withdraw, saying her problem was she believed him too much. I'm curious what the state's position is. Is it that she was competent, or in the words of Jennifer Nichols, dishonest and unethical? For recording her work. Can you imagine if we didn't have the recording of Dinsmore and I was trying to tell you, Judge, I think there was perjury suborned during that day. I think Dinsmore said he didn't remember. If I didn't have a recording, they'd be like, whatever, trust us. Which brings me to the third large point. When you reflect on this case, whose presentation provided you the most credible proof? Whose statements to you were true? I told you from the beginning in May, Your Honor, Katie Spirko won't be a witness. You look in the record right now to see if there was ever a subpoena issued for her today, served on her today. I said it's for a nefarious purpose. Opening statement. The state said, if there's anything new that comes to this court, it's not going to be credible. I submit I have presented to the court objective scientific data that cannot be manipulated, like testimony of a fisherman 14 years earlier. The state has provided testimony from witnesses who lied about everything until their lies were nailed down to the lies of others. It was, at one point I asked a question and General Hagerman volunteered, this isn't gamesmanship. What else is it? If you don't think Jason Autry did it, then why continue to try to put him to death in pleadings? And his answer was, well, we didn't know who was going to be tried first. This is not a game. I've told you about the .32 revolver that we've never found from Dick, the second one, apparently. It's been in a pond. Think about this. The state has asked you to consider the prior evidence, which is part of the record, that Zach made all these statements to drug addicts, to friends, to girlfriends he was fighting with, and somehow confessions. They have incarcerated him since March of 2014, had the ability to wiretap every single thing he's ever said, listen to every phone conversation he's ever made. They don't have the first sentence uttering a single statement that he had any knowledge of what happened to Holly Bobo or any involvement. They say that he threatened his brother. If that's the new element for first-degree murder, every parent who has children better watch out. And look at the people who supported the scientific evidence. Look what happened to them. Terry Dykes taken off the job. John Walker reported. Jennifer Thompson, antidepressant medicine. And Your Honor, I submit, I have shown this to you, and in this case, I have taken their witnesses and their evidence, with the exception of Paul Dillon, Alberto Davis, and Bradley Strong. No, sorry, that's their witness. And the lawyers involved. I've taken their IRs, their agents, and shown you the truth. Your Honor, we're now time for me to tell you the fourth part of this argument and the last part of this case, which is your signature to the order. This procedure, this post-conviction procedure, Rule 28, and it's codified, reflects our country's dedication to the importance of our Constitution. Just as Marbury versus Madison said, some laws, however popularly passed, will not stand if they're unconstitutional. Neither will a jury verdict stand if it's the product of a constitutional violation. These provisions are not trivial. Due process, effective assistance of counsel. I will not lecture the court on the Constitution. I will just say this. It's what our men and women in uniform defend with their lives. Every judicial oath states you solemnly promise to support the United States and Tennessee Constitution. Each generation of Americans inherit the obligation to honor it. And if they don't, it will not stand. At times, it requires good and honorable men and women to speak up and stand up for it against powerful and popular forces. Is your signature going to be easy? Your Honor, it's not. The Constitution doesn't care if it's not easy. To put it in more practical sense, can TBI officers go around telling other witnesses to change their testimony to nail down with other testimony, and can prosecutors say, that's fine, let's use it? We'll find out with your signature. Can a prosecutor lie to the jury about a bullet size? We'll find out with your signature. Can a citizen honestly be said to have had effective assistance of counsel if the attorney was ridiculed, her first chair abandoned her, she had mental health problems, she never presented alibi evidence, she did not understand what evidence is important and how to get it admitted? We will find out with your ruling. Can the state mislabel, then lie about its existence? Evidence that either exonerates or tends to exonerate the witness, and then when they find a more clear version of this evidence exists, can they surreptitiously obtain it and tell the custodian, don't say a word about it? We'll find out with your ruling. Here's the irony, Your Honor. This ruling's not going to affect me. I'm going to go back to Hickman County and divorce people. I can tell you who is waiting on your ruling. Every dishonest member of law enforcement and prosecutor that is faced with a weak case. Your green light, if you condone this, will be the best they could have ever hoped for. And to be clear, I am not saying every law enforcement or prosecutor in this case or throughout the state is either dishonest or corrupt. We live in a state that prides itself in law enforcement, and we should. Those who do their job honorably have the utmost regard for everyone in this courtroom. It is to them this court owes the duty to not reward the bad conduct that besmirches their life's work. I would read to you from page 504, retired agent Joe Walker, to be your guiding light. If there's evidence that cannot manipulate that Zach Adams was not part of this crime, you want him out of jail, don't you? If Zach Adams was in jail unnecessarily, sir, I couldn't sleep at night. I can promise you that. Is today the first time you learned that you did not look at the right video? Yes, sir. Do you feel terrible? Again, sir, I don't know. I don't feel terrible until I know for sure. You're worried, aren't you? I would hate to think that it would be, but I'm not certain at this point. No, sir. Chaucer wrote in Canterbury Tales, if the gold rust, what chance does the iron have? If Chaucer were here, he would say it this way. If this conduct in this case is not corrected in such a high visibility case, what's going to happen to the low visibility ones? Your Honor, subject to any post-trial filings as the court requires, this largely concludes my appointment to the court under Rule 28, Section 610C2, whereby I have reviewed the pro se petition, filed the amended petition asserting other claims which the petitioner was arguably entitled to, interviewed relevant witnesses, diligently investigated and presented all reasonable claims. To say that this has been disappointing and at times disgusting and even intimidated to present to the court would be an understatement. I read no such exceptions to Rule 28 that could have made this easier for me. I would be lying if I did not say I wish such exceptions existed at times. I found myself this summer working late at night often on this case and moving offices across the square in Centerville. One artifact I came across was an article in the Hickman County Times from 1981, where the then assistant prosecutor resigned because he was so upset at the corrupt, dishonest judge who presided over the court. The prosecutor not only wrote the resignation to the judge and the DA, he allowed it to be run in the Hickman County Times. The letter reviewed in detail the horrible acts from the bench this prosecutor had witnessed. And he ended it by acknowledging that this resignation made public will cause a financial cost to his future that he regrets. But he would rather his children grow up poor than to witness him stand silent in the face of such corruption and dishonor from the very institutions we cherish most in our country. The author had a daughter who has since taught history and government and a son who followed in his footsteps. For the reasons I have cited to you,